You're going to have to make a decision on what you want to do with the rest of your life. If you want to be in the prison the rest of your life, I guarantee you Texas has a prison available for you. If you don't change your ways, you're going to find yourself in and out of somebody's jail and in and out of somebody's prison. You're going to wake up and find that a majority of your life has been spent in confinement. So during these 10603, State of Texas versus Gregory Wetron, can I have parties announced for the record for the state?
Casey Garahan, Your Honor.
Defense?
Blood written out for the defense.
All right. And are you Mr. Wetron?
Yes, Your Honor.
All right. Counsel, have you received all the discovery in this case and did you review it with your client?
Have you, Your Honor?
Court will find that the state is in compliance with discovery. And Ms. Abrams, there's no application on this case. Mr. Wetron, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving individual paragraphs.
Any objection?
We're also waiving count two.
And we're waiving count two, Your Honor.
Any objections?
No objection.
All right, then it's the court understanding that you're proceeding on count one. Is that correct? State and defense?
It is, Your Honor.
It is, Your Honor.
Mr. Wetron, I'm showing you what's entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into this plea?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
All right, off the record. Mr. Garahan, I gave you the wrong copy. Thank you.
Here's the right one.
I didn't think.
Yeah. Counsel, do you believe your client is currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Wetron, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, yeah.
Has anyone promised you anything other than the plea? Satisfied with the way you've been represented? As citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count one. Punishment is to be assessed at 12 years in the prison. There's an affirmative finding of deadly weapon. There is no applications and several cases will be taken into consideration. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There are none.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State exhibit number 1 with all of its attachments.
Any
Reviewed the
objection?
document and have no objection, Your Honor.
All right, state, you may continue to confer.
Thank you.
Mr. Wetron, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence its exhibits 1 and attachments and review the same.
The atmosphere inside the courtroom turns heavy as Judge Boyd shifts from sentencing to delivering a hard truth Gregory Wetron cannot escape. After accepting the plea agreement and imposing a 12-year prison sentence, the judge speaks directly to the 41-year-old defendant about the direction his life has taken. Her words are not filled with anger, but with blunt reality. She explains that there comes a point where every person must decide whether they are going to continue repeating the same mistakes or finally make a change before it is too late. Judge Boyd warns Wetron that years pass faster than people realize, and if he refuses to break the cycle of violence and criminal behavior, he could eventually wake up to find that the majority of his life has been spent in confinement. The courtroom grows quiet as the seriousness of the moment settles in. Wetron is no longer just facing another case, he is confronting the possibility that this sentence could define the rest of his future. The deadly weapon finding attached to the conviction ensures that even after prison, the consequences will follow him permanently, stripping away his legal right to possess firearms or ammunition. Judge Boyd's message becomes more than a lecture, it is a final warning about accountability, choices, and the reality of where his current path may ultimately lead.
After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just follow the plea bargain.
All right, the court is going to sentence you to 12 years in prison, give you credit for any time served. There's an affirmative finding of deadly weapon. Court will take in consideration the following cause numbers: 2017 CR 7677, 4641, 8564, 2018 CR 1479, 2017 CR 10602, and 7678. Is there anything else with regards to sentencing?
Nothing further, Your Honor.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Wetron, from reading the police report, it appears that there may be more going on than that's in the police report. How old are you?
41.
You're going to have to make a decision on what you want to do with the rest of your life. If you want to be in the prison the rest of your life, I guarantee you Texas has a prison available for you. If you don't change your ways, you're going to find yourself in and out of somebody's jail and in and out of somebody's prison. You're going to wake up and find that a majority of your life has been spent in confinement. So during these 12 years or however long you serve, you need to start looking internally on where you want your life to be. You understand?
Sure.
All right, good luck to you.
As the hearing comes to a close, the weight of Judge Boyd's words hangs heavily over the courtroom. Gregory Wetron, now facing 12 years in prison for aggravated assault with a deadly weapon, stands silently as the reality of the sentence begins to settle in. What started as another criminal proceeding turns into a deeply personal moment about accountability, wasted years, and the consequences of violent choices. Judge Boyd's final remarks make it clear that this is more than just punishment. It is a warning about the direction Wetron's life has taken and where it could ultimately lead if nothing changes. The judge reminds the 41-year-old defendant that time moves quickly, and every decision carries lasting consequences. With a deadly weapon finding permanently attached to his conviction, Wetron will carry the impact of this case long after his prison sentence is complete. The courtroom grows quiet as the seriousness of the moment becomes impossible to ignore. There are no dramatic outbursts or celebrations, only the sobering realization that another life has been shaped by years of poor decisions and violence. As deputies prepare to escort him out of the courtroom, the emotional tension remains undeniable. Judge Boyd's lecture serves as the final message of the hearing. A person can either continue down the same destructive path or choose to change before it is too late. The case closes on a powerful and emotional note, leaving viewers with a stark reminder of how quickly freedom, time, and opportunity can disappear when anger and violence take control.